Good morning. Today we're going to focus on an issue, a social issue. It's called the Brown versus Board of Education. Brown was a young lady. No, she wasn't. She was a little girl, a little 5-year-old girl who just wanted to go to school. That's all. During the 1950s, Black children could not go to school with white children. It was against the law. But this little girl was so determined that she took it to her parents, and her parents took it to the Board of Education. The Board of Education said, nope, she can't enroll, she has to go to the colored schools. We were colored back then. We were an African American. So the father didn't like that. So what the father did was he contacted the NAACP. And when he contacted the NAACP, he got a hold of a gentleman by the name of Thurgood Marshall. Now, Mr. Marshall was the head of the Legal and Educational Fund for the NAACP. And Mr. Marshall said, we're going to take this case to the Supreme Court. And we're going to let the Supreme Court decide whether or not this little girl, Linda Brown, can go to school in the all-white school or not. Now, during this era, the Jim Crow laws, which were another word for segregation laws, which means that Black people couldn't drink out of the same water fountains, use the same bathrooms, use the same waiting facilities as white people could. There were separate facilities, but yet they were equal, so they say. They were never equal. By the early 1950s, the National Association for the Advancement of Colored People, they were working on ways in which to challenge these laws, especially the laws in the South. Because the laws in the South said Black people couldn't go into restaurants and eat. Black people couldn't rent cars. Black people could not go into a hotel. If they were coming from out of town, they couldn't stay in a hotel. So the NAACP decided to challenge these laws in 3 different states: South Carolina, Virginia, and Delaware. And in doing so, Linda Brown's father, Oliver Brown, who was a minister, he presented a class action suit against the Board of Education of Topeka, Kansas. And in 1951, after his daughter Linda Brown was denied entrance into the Topeka all-white elementary school, these schools were not equal. They were definitely separate, but they were not equal. Take a look at these pictures, will you? This is the picture of the Black school where Linda was a student. Do you see any desks? No, you see the children sitting on benches or pews, but no desks. As opposed to the white school, they had desks, all nice, little neat rows, and the floors looking nice, and even the doors looked nice. But not so. So equal protection under the law, equal protection clause of the 14th Amendment, segregation violated the so-called equal protection clause of the 14th Amendment, which holds that no state can deny any person within its jurisdiction the equal protection of the laws. So they took it to the US District Court there in Kansas first. And it was agreed that the public school segregation had a detrimental effect upon the colored children and contributed to the sense of inferiority, and still upheld the separate but equal doctrine. So they didn't get anywhere with this court. Black children still had to go to the black schools, white children still had to go to the white schools. Okay. But 4 other cases that resembled Brown came before the Supreme Court in 1952. So what the Supreme Court did, they combined these cases and they named all the cases, placed all the cases under one name, and they called it Brown versus Board of Education, Topeka, Kansas. And here's the Supreme Court of 1952. Thurgood Marshall, which is seated here, he was head of the NAACP Legal Defense and Educational Fund, and he served as the chief attorney for the plaintiffs. 13 years later, President Lyndon Baines Johnson would appoint Mr. Marshall as the first Black Supreme Court justice. So at first, the justices were divided on how we're going to rule this case. How are we going to rule this case on school segregation? Well, the Chief Justice at that time was Chief Justice Fred Vision. He held the opinion that we should keep Plessy verdict in place. All right, keep the schools separated, period. But in September of 1953, before the Brown case came before the Supreme Court, Vincent had a heart attack and died. And President Dwight David Eisenhower then replaced him with Earl Warren. At this time, Earl Warren was the governor of California. Very, very liberal. So displaying considerable political skills and determination, this new Chief Justice succeeded in engineering a unanimous verdict against school segregation in the following year. That would have been 1954. So in the decision issued on May 17, 1954, Warren wrote that in the field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal. As a result, the court ruled that the plaintiffs were being deprived of equal protection of the laws guaranteed by this little document called the 14th Amendment. So in this verdict, the Supreme Court did not specify exactly how the schools should be integrated. So he asked for further arguments on it. But in May of 1955, the court issued a second opinion in the case known as Brown versus Board of Education, which remanded future desegregation cases to lower federal courts and directed district courts and school boards to proceed with desegregation with all deliberate speed.
On May 17, 1954, the U.S. Supreme Court issued its landmark decision in the case of Brown versus Board of Education. The court ruled unanimously that racial segregation in public schools violated the Equal Protection Clause of the 14th Amendment to the Constitution. This decision grew out of several cases that challenged racial segregation in schools across America. Because the lawsuits addressed the same legal questions, the Supreme Court consolidated them into one case. Its lead plaintiff was Oliver Brown. He sued the Topeka, Kansas Board of Education on behalf of his daughter, Linda. She was a Black public school student who lived just a few blocks from an elementary school in Topeka.
Now, just because the Supreme Court issued this decision, it did not take effect immediately. Many schools decided, especially those schools in the South, they said, we're not going to admit any Black children, any colored children into our schools. In the state of Virginia, they chained the schools, they put chains on the doors of the schools so that no one could get in. And those schools in Virginia remained closed for a year. Not just Virginia, but North Carolina, South Carolina, Alabama, Georgia, Florida, Mississippi, Tennessee, all did the same thing. Schools remained closed for a year. In Little Rock, Arkansas, 3 years later, the NAACP challenged that law, that new law, when it sent 9 young Black children to a high school in Little Rock, Arkansas, to integrate that white school, Little Rock Central High School. It didn't go so well at first because the Governor Faubus, did not want any Black children in his school. So he sent out the state guard to deter students, the Black students, from coming into the school. When President Eisenhower got wind of that, he nationalized those guards. So now they're federal troops, and they had to escort these students in to the Little Rock School. Integration in our public schools in America today.